There's not supposed to be any light.
Директор IFES Україна, а також Юлія Кириченко, керівник проєктів з питань конституційного права, Центр політико-правових реформ. І я передаю слово панові Пітеру.
Thank you very much, moderator. If you don't mind, I'll quickly stand out during my opening remarks. My name is Peter. I'm the director for IFES here in Ukraine, and I have worked the last nearly soon to be 30 years on elections around the world. I'm particularly passionate about referenda issues because I have seen referenda issues become fundamental, pivotal to the future of states, of democracies around the world. And therefore, I am especially pleased that I have the opportunity to say a few welcoming words to all of you today. This is clearly about you, your nation, and in no way about me, and hence I will make it short so that we can quickly get to your presentations and to discussing the matter at hand. There is no doubt that there is significant issues with regards to the legislation which currently governs referendums in Ukraine. These fundamental issues must be addressed. If we look at it from an international standard and a European standard point of view, there are significant shortcomings that a striving democracy, a strong democracy, would not want to have. And as many of you national experts, as international experts, as the Venice Commission has clearly stated, the referendum legal framework must be reformed. It is immensely important that there are safeguards in place to ensure that should referendum ever be needed, that these are called for and handled in a responsible manner. I think it is particularly important to stress that we are not here today to encourage the use of referendum as an instrument. I personally believe referendums should be used very sparingly, only when there are a very significant national issue that needs to be addressed. I'm also well aware that there has been recent referenda in our neighborhood, for example Brexit, which might make people concerned about talking about referendums at all, because sometimes we are concerned about their outcome. But we should not let a problematic piece of legislation stay in place because we are afraid of referenda themselves. I think that if we are concerned about referenda, then we must make sure that should these ever happen, that they happen on the best possible legal basis. And they happen in such a manner that the decision on whether there's a referendum or not and how this referendum is called is one in which the people participates, particularly through their representation in their parliament, in your case, the Rada. So I would encourage that the discussion today is not seen as encouraging the use of referendum as an instrument, but rather to make sure that should this instrument ever be used, often leading to pivotal moments in the history of nations, it will be used in a very responsible manner. I also believe there is another issue which is important. Referenda may not attract much public attention when they are not called for, but it is when they are not called for in the quiet period in between that we can change the rules of the game, that the legal framework can be adjusted so that it best underpin a possible future referendum. We see very clearly that once a referendum is needed in a nation somewhere in the world, people scramble to try and repair how the referendum is to be held. Questions such as who should formulate the very important question of the referendum certainly become central, and often it is too late to change the legal framework. So it is in this period where there is least attention to the issue of referendums that we can make the most good in terms of strengthening the way in which referenda may one day be called in your country. So, for change, the time is now, so that this change is manifested and ready for the day, hopefully in the far future, when a referendum will be needed in your nation. And hence, I salute you all for being here today and for taking this opportunity to discuss this very difficult issue. And hopefully, it will be possible to strengthen your framework for holding referendum at a time when it's meaningful and when it can actually be to the good of your nation, should one day a referendum be called. Thank you very much for being here.
Дякую.
Thank you for your attention, for listening even to those who didn't put on the headphones. I understand that everybody understood it in English. And then Yulia Kirichenko, head of the project on constitutional norms, will continue. Yulia, the floor is yours. Thank you. I welcome all participants of forum today in this day, which is historic for Ukraine. Today it's 25 years since democratic referendum was held in Ukraine, when we proclaimed independence of Ukraine. Today we chose this day not by chance, and we chose this historical building where Central Rada was meeting many years ago. First of all, I want to thank International Foundation of the Electoral System, which is supporting civil society since 2001. When civil society noticed the threat that the law on referendum adopted on the 6th of November of 2012 was adopted, that was one law of the entire chain of dictatorship laws. All the other laws were cancelled, but this law, for some reason, remained in force. And probably it's not by chance we hear today that administration president is mine. I think this law is a mine, a kind of explosive clockwork mine for entire country. In your files, you have some bulletins, the ballot papers, and we shall hold a referendum today based on the procedure which is in the current law. We have representative of Central Election Commission here. They gave us a ballot box, so you all vote. Put your ballot papers into the box and we shall see what will be result in this well-educated audience. I welcome all participants once again, and I hope that today we shall be able to draw attention both of society and authorities to the threats that remain when this law on national referendum of Ukraine remains. We call this law named after Yanukovych Medvedchuk. I wish you all fruitful discussion. Please get engaged, ask questions to clear out all details of this story with national referendum and local referendum in Ukraine. So, once again, I shall repeat the procedure. Each of you has a ballot paper in your file. You can vote freely. Put it into the ballot box. Then the organizers collect it. Counting will be based on old law. We shall vote according to the procedure prescribed in the current law, and collection and processing will be based on the current law. Maybe by doing that we shall influence the policy of Iceland. That will be according to Ukrainian law. You also have ballot papers that were used at all Ukraine referendum in 1991. One of them prepared by Ukrainian authorities and one prepared by Soviet authority. The Soviet one, it is actually in conformity with the current referendum law. But the one which was prepared by Ukrainian authorities, this one would not be recommended probably then. After each of the block of discussion, you will have the chance to ask questions to our speakers, although they said not to ask questions. I'm joking. So this is the end of introductory speech. Thank you. And now I invite to the podium participants of the next session. Dear Vladimir Shapoval, a judge of Constitutional Court of Ukraine, resigned. He is also the former chairman of the Central Election Commission of Ukraine, corresponding member of Academy of Science, a doctor of law, professor. I also invite Silvana Zalivchuk, who actually caused the wave of applause. She is member of parliament, and she has drafted a new law of Ukraine on national referendum. Representative President right, Leonid Yemets, People's Deputy, Representative Interfaction Union Euro-Optimist. Nobody from administration of President. They're busy now. Igor Koliushka, head of the board of Center of Political and Legal Reforms. And Petro Stichuk, a judge of Constitutional Court of Ukraine, retired. He is also a doctor of law. So, I invite Volodymyr Shapoval. Please, the floor is yours. I think I can speak while sitting. Only if it is in conformity with Ukrainian law on referendum. I'm not voting, although I will vote. The title of today's event is Rescue Referendum. Therefore, you should vote to rescue it. So, good morning, dear friends. I would not start from common things, but it is a Memorial Day today. I remember very well that day when we were all filled with huge enthusiasm and we all were voting at referendum. There were elections and a referendum at the same time. As regards elections, there was less enthusiasm, but it was a Memorial Day. The day looked very much like today. It was snowing, maybe a little bit less snow than now, but this was quite an extraordinary event in Ukraine. I was deeply convinced that then, sorry for going to memories so deep, and at that time I was not an organizer, I was just a participant of the referendum. At that time, all the procedure was so fair, as much as it is possible to be fair at all. It was quite fair and transparent voting. There was no desire to falsify or to abuse. Of course, you cannot exclude individual cases when some voters acted not in conformity with the law, but it was the first real referendums in the history of independent Ukraine. I would not make comparisons with what happened in 2000, because at that time I was a judge of the Constitutional Court who was considering the case on that. Things were more difficult then. That day in 2000 should not be remembered. Problem of referendum for any citizen of Ukraine, and moreover for lawyers or jurists, is quite irritating. And today's title of the event, Rescue Referendum, one can agree with it or disagree. Rescue someone is very radical word, but we are rather appealing not to people, we are appealing to authorities. The authorities that existed before 1990, at that time we practically didn't have legislation on referendum, although even constitution of Ukrainian Soviet Social Republics, constitution of Article 5 was saying that most important issues of public life should be resolved at national referendum, all Ukrainian referendum. But what for Soviet authorities should call referendum? They were not. And this trend continued further. What was symptomatic? The law on all Ukraine and local referenda was adopted, if I'm not mistaken, in July 1991. That was the time that Act on Independence of Ukraine was adopted. And this law on referendum was adopted for a particular referendum that was adopted 25 years ago. If you do a law for a particular event, for a particular referendum, it's not so good. If you do something only for musicians or for other professionals, it's not good. And Article 5 of the Constitution, that includes principle people's referendum, says that this is a direct use of power of people. And when adopted a particular law and referendum, after this law was marred so much in 2012, actually that destroyed the power of people to call referendum, to participate in referendum. Having bad law in referendum, that is infringement of the principle of people's sovereignty. I shall tell you as a jurist who is dealing with this issue for a long time. Quite interesting thing regarding current law on referendum. These are just my reminiscences of a citizen and jurist. Quite an interesting circumstance. I shall remind you, the current law was adopted in November, 6th of November. November is a particular month for us. All is done when weather is bad, when it's snowing, it's getting dark soon, in winter. All dark things are done. Quite an interesting circumstance. That was quite indicative law. Remember, in 2010, the Constitutional Court, when I was not a member already, renewed the old Constitution of Ukraine of 2004 and renewed all the powers of the president. All was done the way it should have been done. And then the law on referendum was adopted. People who read this law unbiasedly, not politically biased, saw many inconformities with Constitution. I shall not analyze this old law, but I shall tell you how it was adopted. I was in a particular position at that, but I was saying publicly that this law is not in conformity to Constitution. I was the chairman of Central Election Commission then, and I was saying I shall make all possible that referenda in Ukraine are not held based on this law. Then the question, what for this law was adopted? I wouldn't like to be a fortune turner, but the then authorities had inferiority complex. They used constitutional courts, they changed the constitution, they renewed powers of the president. in the previous version of Constitution, and then we're preparing to full legalization of authorities, because it has a symptomatic norm of the new constitution that could be adopted by referendum. If you read this law on referendum, you will see the main idea is to have possibility to change constitution or adopt a new constitution based on this law on referendum. That was the main task of this law. In November 2013, when Maidan was already in place, a group of people, among whom I was also, with the help of IFES, and we are very thankful to them for that, for their efforts, we drafted a new law on national referendum. But again, it was symptomatic. We were drafting this new law not for Maidan events, not for the possible new authorities. We didn't know yet that the new authorities will come. I don't want to make any political assessment. At that time, nobody knew whether the devil will get out of the box. So we drafted a new law. Members of parliament, group of members of parliament, initiated submission of this law. So they admitted it to parliament according to the procedure. I didn't want to make predictions, but I have a particular feeling. Referendum is a very speculative thing. I remember that one of the leaders of one political force, communists, was saying, if you want to join NATO, only through popular referendum. So politicians use topic of referendum when it is beneficial for them. They say, we are for referendum. It's not useful for them. We are against referendum. It's very irritating topic. I'm very concerned about the destiny of this law. I shall not take responsibility to conclude that it is not perfect or it is perfect by members of parliament who were working on the new draft law on the referendum were doing it fairly. And in order to rescue referendum, here we should have the people who represent majority party. I'm surprised not to see here Member of Parliament Kniazevich. I remember when he was a member of Central Election Commission from Batkivshina party then. Why he's not here? Because I would approach him and ask, Ruslan, what stops you from voting for the new law on referendum in Verkhovna Rada? Why it is not in the agenda of Parliament? So, dear friends, my congratulations to this Memorial Day of referendum on independence. Thank you for your attention. Sorry for taking too much time. Take too much time. Yes, because what you said first looked like you drank too much. You don't look like that. I give the floor to Svetlana Zalishchuk. My only request to all speakers, since Volodymyr fairly said that he took too much of time, Svetlana, you have, and others, you have less time. Thank you very much. Good morning, dear friends, dear participants. Probably I shall start from common things again. Today we are talking about law and referendum in a very interesting historical moment when we see that due to the most democratic mechanism in the world, history sometimes is made within the scope of sociological era. I mean referendum in the Netherlands that decided the destiny of our European integration, and referendum in Great Britain, Brexit. We are witnessing how democracy is looking like a very delicate lady, vulnerable lady. But geopolitical discussion held on that focuses attention on our law on referendum. Results of referendum in 1991, it was not so sociological era. it was real decision. At that time, I was not of full age to vote at the referendum. But I'm thankful to other people of Ukraine who voted for independence of Ukraine. The organizers asked me today to say a few words about history of our coalition and the procedure that we communicated to draft a new law. Mr. Shapoval has made several comparisons today already, but I must say that the draft law registered in Parliament is not just something instantaneous. That is the law developed with participation of the best lawyers and specialists in this country, politicians and civil society. And it's important that such decisions are made not because of the desire of a particular president, no matter what his name is. This law should become an instrument in the hand of people of Ukraine. I shall remind several historical issues. As you know, law and referendum in the times of Yanukovych, that was part of those least democratic laws. Same as laws, draconian laws adopted on the 16th of January by Yanukovych Parliament. The law on referendum adopted 6th of November 2012 was the most terrible. Mr. Kolyushka will tell more on that, because this law allowed to change constitution by referendum, to change territorial integrity of our country by referendum, and even elect the president. And this law is still in force. When this voting for this law happened in Parliament unconstitutionally because there were less than 100 deputies in the session hall of Parliament. That was the last day of that convocation of Parliament. That was done unlawfully. Again, in the evening, in the quiet. After that, since such things caused indignation of the people, we created a coalition, an NGO, for fair referendum. We not only protested against this unlawful law, our task was to develop a new democratic law, which, provided that regime is changed in condition, we would have possibility to register in the parliament and approve it. This group included Volodymyr Shapoval and Yuri Klitschkovsky and Igor Kolyushko and Yulia Kirichenko, Oksana Serid and many other colleagues. I even will not be able to mention them all. We were working on this draft law for 2 years. It was mentioned already. At that time we didn't think about possibility of Euromaidan. We didn't know how history will develop. But for us important was to have an alternative law that we could submit to Parliament at a proper moment of time. I shall remind you that we have submitted this law to Parliament when we became members of Parliament. I had the honor to register it. I am one of the co-authors of this law. Moreover, on the 1st of December 2014, we also made submission to Constitutional Court of Ukraine. What we wanted that this current law on national referendum is called unconstitutional, but consideration in Constitutional Court still continues. Leonid Yemets will tell more about this stage in Constitutional Court. So I will summarize my presentation. Few conclusions. What are our main tasks now? The current law, which is still in force, is absolutely undemocratic. It is unacceptable for it to be used. Second conclusion. New law, developed inclusively with participation of civil society and members of parliament that took into account the recommendation of key international institutions in this sphere. It is submitted in parliament, but we must say it is blocked. There is no political will to vote for it. And this is the task of us, members of parliament, and we all must get engaged into public discussion to exercise pressure to move it. And last but not least, the current convocation of parliament should prove that we are a democratic parliament. And this new law will be adopted by this convocation of parliament. And I think that the society will assess the results of work of this convocation of parliament based on this conclusion, how we could adopt this law and guarantee basic voting right of people. Give the floor back to you.
Thank you, Svetlana, for saving our time. Only I'm suspicious about how do you know what next two presenters are going to talk to us about. This looks like Grey Cardinal to me. Leonid Yemets, MP, is the next one, Euro Optimist International Association. Good afternoon. I'm also a co-author of this draft law. I'm a co-author of another draft law. However, I'm making this presentation on behalf of the Euro Optimist Association. However, on the Facebook, you can the statement is posted about the background of Interfraction Association supporting this draft law 2145A. And Euro Optimist is also reminding that it is the obligation of the Parliament to ensure the right of the community to local referendum. We are talking now about all Ukrainian referendum. There is also local referendum, the right to it set forth in the Constitution. This law actually of 2012, it prevailed over the law on local referendum. So, meanwhile, why do I like Euro Optimists? Euro Optimists, we do not render decisions because someone wants it or someone wanted to promote the idea. No. We have had the discussions. We have some projections, like in referendum in the Netherlands. We have the cases of pseudo-referenda in Crimea, Elena, the DNR, and therefore, we are now talking about this draft law, and one of the fundamental rights, human and civil rights, is a referendum. That's according to the Constitution, and therefore we have to discuss how it should be handled. This current law does not meet any criteria, so that we could state that the referendum will be fair and will demonstrate independent will of Ukrainian citizens, and that it will not become an element of political influence or manipulations, etc. Therefore, this law needs to be changed. There were two options. One is to cancel this law on all Ukrainian referendum, and this will give room for a previous laws that we had in the past, including the one on local referendum. However, we decided on another option. We drafted the law that was submitted to the Parliament. Now it is up to the Parliament to pass this law. It has been mentioned today that there is no political will. However, let me tell you this: according to the Constitution, there is only one way to limit the civil human rights and freedoms. This would be martial law. Until that time, the law on referendum, according to the Constitution, should be adopted. There is no alternative to that, and so this is only about the failure to act of the Parliament that is and must safeguard this right to referendum. So what will force the Parliament to do this? We have all of us to engage all stakeholders, society, communities, MPs, and civil society, all other actors and entities appropriate that will force the parliament to pass this law. Sooner or later, we will face the issue about what needs to be done with Donbass. I'm sure that Donbass and Crimea will be back to Ukraine, however, later. However, I believe this is up to Ukrainian communities and society to decide about what we do. Then later, this is also disputable issues, but for later. Local referenda. Of course, if we listen to the people as for referendum, a local referendum, for example, there are some opinions that it will give way to separatism. No, it will not. It will not. Local referenda will address local issues, and they will never address the issues of territorial integrity or language. As for, remember this issue of theater in the St. Andrews descent of the theater. No. This was a huge mistake to touch upon this issue of the theater in the St. Andrew descent. Because there may be fighting at the end of this conference here. Well, this is this new building. There is a lot of many confrontations and opposite opinions about this theater. However, even on the Facebook, you can see that people express their opinions. However, when they have a referendum, then we see a totally different question. Or during the election, I'm not talking about the referendum. If there is election, people vote for opposite ideas. So we can, for example, have an idea of our general position, and then it will turn out that the community has a totally different position. This is the very objective and purpose of local referendum. This is the right of the community to address this kind of issues, local issues. And so we have done everything that we could. We need to engage society now and media. That's why we are addressing you to help us to implement this law. I believe if we all get together as one fist, we will manage. Thank you, Leonid. I give the floor to Igor Liushko. He is Director of Board, Center for Political Legal Reforms. Thank you for giving me the floor. I will also draw back on some historic reflections. My colleagues have mentioned many things, however, they never mentioned about how this law was drafted and adopted. This current law, the draft was submitted in June 2010, and it was drafted. Somebody mentioned the surname of Medvedchuk. I don't know what his contribution was, but I know for sure that it was drafted by Lavrinovich. Lavrinovich, Minister of Justice, was involved in the process, and the idea of this draft law was as follows: that they wanted to manipulate with the constitution, the way they later manipulated it by the constitutional court. Why I'm saying this? When in early July 2010 the parliament reviewed this draft law on all Ukrainian referendum, there were evident unconstitutional provisions, for example, about the procedure for amending the Constitution. It's clearly described in Section 13 of the Constitution, and in that draft law, this was to be the subject of all Ukrainian referendum. And then the parliament, even then, when they voted, even that parliament, Verkhovna Rada, when they voted for this draft law in the first reading, it wanted to delete the provisions regarding the potential changes to the constitutions that could be made by the decision of all Ukrainian referendums. Then after that, nobody ever brought this draft law to the second reading. I remember there were discussions, and it was current Minister of Justice Lavrinovich who actually decided that this law was no longer relevant. So it was on the shelf of the parliament until after election. Now this parliament was re-elected, and all of a sudden they included it on the agenda of their meeting, and they were voting for it, and so they voted for its full adoption in the version that passed the first reading. This was not clear about how this complied with the rule of procedure. So, because there was previous decision of the parliament that was overturned by this voting. This is the proof of evidence of manipulations. And the procedure of adoption of this law was unconstitutional, was against the rule of procedure. That's how this law on all Ukrainian referendum came into place, and we, the public, raised discussions. We wrote a lot about it, and we appealed to the MPs of all factions to make a submission to the Constitutional Court. However, not all factions were ready to do this, and even though this submission was drafted by experts and MPs were only to read it through and sign under it, still one of the factions, I was not sure whether I should say who they are, since Leonid Yemets, he was clearly stating the names of everyone involved. However, at that time, factions were slightly different, and we were strongly surprised by why those politicians who we always believed were pro-democratic and were fighting for the constitution, the rule of law in our country, all of a sudden became opponents of making submission to the Constitutional Court about the unconstitutional nature of this law. And this submission was only made in 2014 or even 2015 after the election. So, however, I was asked to remind you what was so bad about this draft law. First of all, number one, the subject of all Ukrainian referendum would be the issue of making amendments to the constitution or making changes to the constitution of Ukraine. This was non-compliant with the constitution, and as for another thing, such as adoption of new constitution, this is difficult to say about it, because there is nothing, the constitution doesn't say anything about such opportunity. Now, the procedure of adoption of the law, also was another issue here. Another risk in this law is the procedure of preparing to the referendum. Actually, it includes no protection with regard to manipulations, for example, to the issue of manipulations that may be become subject of all Ukrainian referendum. According to this law, it is not possible to have a referendum without support of the government, and this implies manipulations because I don't know. Even if we have to collect signatures to initiate the referendum, even the dates of collection of the signatures is not feasible. And also, when the referendum is announced, there is a provision there that any media may publish any opinions with regard to the issues related to the referendum only based on the contracts or agreements that have been executed. So none of us experts who have good knowledge of the constitutional law would not be able to express their opinions in media according to this provision. And also I want to remind you that this law cancelled local referenda in Ukraine, and up to date the law on local referenda in Ukraine has not been adopted, while local referenda have the largest significance, since all Ukrainian referendum is a risk, like national referenda. In many countries, in Germany, for example, after all those huge problems with the Nazi regime, and now they have a ban on national referenda. However, local referenda are allowed across the globe, and they are very good. This is a good opportunity, and we don't have this law, don't have the right to have local referenda. And again, we appeal to MPs. This is the law. There is a draft law on local referenda. It was registered. It passed the first reading. It was awaiting second reading. That never happened. So I would request that you address this issue. Thank you, and thank you for your attention. Now it would be best to show you this short video about what the current law on the referendum is about, and what its effect is.
Якось зліпили у парламенті закон і поклали на підвіконня, щоб просох. А він узяв і втік. І почав закон їсти все. З'їв свободу слова, з'їв мирні зібрання, негарно вчинив з Євросоюзом, потім з'їв вибори, Конституцію, з'їв рідну раду і взагалі усе з'їв. От такий закон, малята.
To Mr. Petro Stetyuk, he is Judge of Constitutional Court of Ukraine, retired. And continuing on this video, following up, I say, dear boys and girls, okay, so how does Constitutional Court fit into this process? MPs mentioned that they made a submission to the Constitutional Court to recognize as unconstitutional the law on the all-Ukrainian referendum on 2012. So what happened next? There was a preliminary evaluation opinion, and it was negative, by the way. There was initial expertise. This was expert evaluation unit in the Constitutional Court, and they wrote this opinion mentioning that with regard to the submission, that the Constitutional Court shouldn't, that this submission was unsubstantiated to open a case for the Constitutional Court. However, this law on all Ukrainian referendum of 2012 when we say just plainly, for example, that it was not harmonized with 1996 constitution, it's to say almost nothing. However, the case went through 3 panels of the Constitutional Court, and what can panel do? They may evaluate the submission, and they may either deny a constitutional proceeding or accept constitutional proceeding. And they did initiate constitutional proceeding in 2012, and they started preparations to the plenary meeting, deciding on the format of this meeting. So what potential constitutional court could have done? There are 2 options again. Option 1, they may review this case per se and render 2 judgments, recognize it unconstitutional, partially constitutional, unconstitutional. And option 2, they may close a constitutional proceeding, which automatically will recognize it as this draft law as constitutional. The constitutional law has not yet rendered its decision. Those cases are still under review. However, I'm not going to give any advice to the current composition of Constitutional Court about how to look into this case. I would like to draw attention of experts and other stakeholders in this process. I wanted to remind them that there are expectations of the societies that may or may not come true. We have to take into account a few circumstances. Number 1, this is not the only case at the Constitutional Court of Ukraine that is being delayed. There is also the Kivalo-Kolesnichenko language law that is being looked into by the Constitutional Court and being delayed. And there are other cases that are being delayed. For example, the law on lustration. There are different motives to hinder the proceeding and to delay the proceeding. But the delay is still there. And so, what is the solution here? There is a solution, and we all know that there will be a way out, and this delay will be sooner or later over. However, but this case, again, it faces the challenges of the composition of the Constitutional Court. Shortly after Revolution of Dignity, some changes to the composition were initiated. However, I would say this: there is all biblical wisdom that you shouldn't pour old wine into new barrels, into old barrels, and this is the only little advice that I would like to share with my colleagues from the fellow judges from the Constitutional Court. In any case, you have to render a decision, and you have to put an end to this unclarity and confusion in the Ukrainian society. Thank you very much. I give the floor now. I give the microphone now to the moderator. I have a question. I will take advantage of being moderator because we will have now a Q&A session. I will be the one to begin. We have few lawyers here. How real it is to prove evil intention of those or that they intentionally drafted this law in this way, using this particular wording. Who will dare to answer this question? Actually, today Also, we compare it against the law on linguistic policy. What the package that we have in the Constitutional Court, all these documents that they have there, they are evidence of manipulations with voting for these laws. There was no discussions, no personal voting. The procedures, rules of procedures were rudely violated, and there is a huge package of documents involving that evidence there and proof of this. Now, what we will do, we will substantiate our position at the Constitutional Court, substantiate it well. Hopefully Constitutional Court will act in a very legitimate manner, and then it will be the objective of Prosecutor General Office to engage in numerous investigations of this verification of this evidence, and then to identify the contribution and the guilt of each and every individual. Like the case of Yefremov is the first of a number of cases that should move forward in parallel. Any other questions? Thank you. My question is, we live in the country of the total absence of responsibility. Your question looks very much like the question that would be the subject at the referendum according to the current law. So again, the president bears no actual responsibility, MPs bear no actual responsibility. Okay, would you form your question, would you agree? No, I will continue. Constitutional Court bears no responsibility. This is the environment of total lack of responsibility. What do we do with it? What and when? Okay, as soon as you start answering this question, you agree that we have the environment of total absence and lack of responsibility. Microphone, please. Okay, there are manipulative statements that we continue coming up with. Okay, absolutely irresponsible MP, but fair. Okay. Yes, if I'm a responsible MP, I would like to share my idea with irresponsible citizens. Well, there is collective responsibility during the election when we see unconstitutional steps of MPs and a lot of corruption, and we elect them again and again into the parliament. This is the quality of electoral process, political culture, and participation of citizens in the elections. Of course, I would say yes, the President, Parliament, Government, they are our leadership, judicial branch. And this current Parliament has already started doing something to and addressing this lack of responsibility. However, since 2014, when the parliament was elected, this trajectory was dropping down, and the capacity of the parliament, the potential to reform without being pushed by the EU and international organizations. And this is a question to us: how can we address this factor? I believe that it is the society should ask the parliament, ask the government, why reforms are not taking place, why why are you not improving the situation with responsibility? But again, the society should ask them questions, should keep them under control, and be responsible at the elections.
Actually, you see, it's the women who decided to be responsible. This is the old tradition to allow ladies first. So, just look, what is the situation? There is responsibility, but only political responsibility. It is periodic responsibility connected with periodic elections. To start responsibility, function truly, we need first of all responsibility of voters themselves. And for 20 years we see that it's not always like that. People are bribed at voting, they take package with food and vote for corrupt MPs. The only situation changed could be the new law on election. It is a draft law on election registered in parliament, but there is no political will of leadership of parliament to vote for it. Then it will help people to pick up who from the party list will have priority after voting. And then you can hardly use any benefits, any bribes. Those candidates on the party list who get real support of the people, they will be voted. Without adoption of the new law on voting, nothing will change. People should support it. People should come and say that they want this new law, same as with the new law on referendum. Thanks to Speaker of Parliament, Andrei Parubi, current Speaker, is one of the members of this working group comprising different factions of Parliament. There are 6 draft laws on election, and we try to agree on one version. Let people come and say also, we are for open party list voting system. Then it will be a fair system, and then will people, voters themselves, will understand that it depends on them whether they vote for particular party, for particular candidates. There is no other possibility. There are other options that are outside the legal framework, but this is the place for other discussion. In follow-up of what colleagues said, we all people should come back to things. We live in a republic. Our country is a republic. Commonwealth, common responsibility. The Constitution has very good article explaining what is a republic. Poland, in its constitution, has clear explanation that Polish as a republic is a common state of all people. Then we should get away from situation when each and every try to take a piece of this commonwealth to his or her side. Probably you should change the voting system, and new people should come to parliament, new people should come to judicial system. I remember what happened in 1991. You remember glasnost was a popular word at that time. Glasnost, openness, was very important in the switch from Soviet side to democratic side. And now this glasnost, this publicity, this openness is very, very important. If we demonstrate all that, if people who are in authorities, who get their salary from our tax incomes, when they understand it, life will be better. It seems to me the question asked was mostly related that there is no responsibility or no liability for mistakes made, for wrongdoing in all branches of authority. If a person is doing something wrong, some people vote for a particular law and organize unlawful voting and nothing happens. They're not taken to liability. Just look, things are easy in fact. The Constitution provides that a Member of Parliament is not liable for results of voting, for pressing the button, yellow button, red button, or green button. But Criminal Code provides for liability for criminal actions, and the frame of case should come to the end, because that will be a precedent. After that, similar cases will follow, and other people will not use such unlawful mechanisms. And this is the task of Prosecutor General Office. We shall see how well they work and bring this case to the end. We all understand that there was a crime and all evidence is provided. So Prosecutor General Office should demonstrate that it doesn't want to keep all these unlawful and democratic methods, but it has the task to bring criminals to responsibility. I want to add a little. I agree with what Leonid said, that there are two types of responsibilities. Political responsibility, whether you will be voted for at next elections, depending on what you are doing. The other is a criminal liability. We are now talking about strengthening our anti-corruptional body in order that they investigate how decisions were taken because of money, of bribes. Now, at last, according to the new law on budget funding of political parties started sending reports. And we see now that Democratic Alliance, this party, has least money, but Poroshenko party has biggest money. I'm afraid of the way he was looking at you, he was staring at you when you were saying it. Second thing, our anti-corruption bureau and anti-corruption and prosecutor's office. Finally, electronic declaration is in place. And many members of parliament and judges think that that was kind of amnesty of their previous incomes. And all millions, churches, and luxury watches declared are amnestied. In fact, that was not an amnesty. Investigation should follow whether they got all these things according to the law, whether they pay taxes, and then other legislation should be applied. Not election legislation, but criminal code should apply to investigate it. But this connection is not by chance that politicians and judges and people engage in making key decisions. They possess the biggest amounts of cash in this country, and they must prove that this kind of responsibility should be proved in the court. And now, a key thing for our society is to keep independence of anti-corruption body, not to allow to discredit them, to keep their powers, and bring to the law, give them the power to overtap telephone calls and bring to the end all criminal cases opened against judges and MPs. Yes, sir. I'm from Democracy International. Thank you very much for this event in such historic moment. Referenda should be held. It is a powerful instrument of democracy, but it could be a powerful instrument of political manipulation. What I would like to hear from you, how to ensure such situation that questions in the referendum are worded in the proper way, that this wording is not manipulation of voters. Look at this ballot paper. Emotionally, it forces us to vote for, but look at the content. What kind of Europe? What kind of economically independent Europe? Family values. What kind of family values? Nothing about democratic foundations. You can formulate questions in a different way. How to ensure such situation that wording of the questions will not become instrument of political manipulation? I shall answer the part regarding preparation of ballot paper. We intentionally formulated in such a way that it is worded according to the current law, and I'm pleased to hear that you noted it, that wording means manipulation. I cannot hear what the lady is saying. What she's saying now is also in conformity with the current law. They will answer the other part of the question. When answering your questions, I want to say that our working group that drafted a new version of the law on all Ukraine referendum, which is submitted to Parliament, paid most attention to wording of questions. Most important thing is to define the subject of all Ukraine referendum. It could not be sizeless, very broad. This is not a democracy. One should limit very clearly what could be placed for referendum and to what extent. Second, you should provide mechanism to check that questions are uniform, clear, to avoid manipulation, because people, when reading this question, can imagine something, but authorities had quite different meaning and interpretation, and they will use the results differently. A referenda should not allow that, and that should be contained in the law. And I invite all lawyers present here in this room to read the draft law attentively before it is approved. Maybe you will originate better ideas and proposals how to ensure such things in referendum. Please address members of parliament. They will be pleased to include your proposals in the law if they contain some new technologically worthy initiatives. The law that is registered in Parliament, does it include the mechanism of formulation of wording of questions? Yes. It has. Yeah, maybe I will give the answer. First of all, in general, one should take a careful approach to it, to the definition of manipulation of conscience, or perception. If a political force wants to achieve a certain goal, wish you it or not, subconsciously it will manipulate. So let's try to avoid it. What legal instruments could be used to minimize all the things that you called manipulation? As far as I remember, this law on amendments to Constitution, it was the law on justice. It's not only on justice, because it's also on the Constitutional Court. Constitutional Court had nothing to do with exercising justice as such. So they added additional power to the current Constitutional Court. Now Constitutional Court is authorized to check whether a particular issue or a particular question of all Ukraine referendum should be checked, whether it's in conformity to Constitution. In some countries, it's constitutional jurisdiction who decides on that. So if the court is not manipulated, if civil society is engaged, if it is a political society of politically correct people who do not take bribes, well-conscious citizens, not all citizens are politically conscious, some of them take bribes packaged with bucket porridge. Constitutional Court is checking it. You want to hold a referendum on cancellation of death penalty. It is not in conformity with Constitution. Or you want to have a question of referendum to cancel a sentence to a particular member of parliament. It is not the jurisdiction of Constitutional Court. But what I'm convinced of legal instruments. Well, something like that. If it is cold in the street, you dress warmly. But that doesn't mean that you will not be warm, because your body should be warm. If our societal body is warm, there will be no manipulation. But if people believe and take bribes, then continue. Problem will continue. I agree with you, but a short question. Who, in the final end, is responsible for the text, for the wording of the question? The government, a political party, the lawyers? Who is picking up the words of the question of referendum? We do not take an abstract situation, but we take Ukraine. Ukraine constitution provides for particular cases when referendum is possible or needed. For instance, territorial changes. Verkhovna Rada is making decision on that. When making resolution on calling referendum, this is responsibility of Verkhovna Rada, both political and legal, if they are working on the text of the question. If referendum is called on popular initiative, things are more difficult. Then you should go to Constitutional Court. It should check whether it is in conformity with Constitution. If Constitutional Court once again takes wrong decision, this is responsibility of Constitutional Court. Now my comment as regards responsibility. In public perception, such approach is dominated. Responsibility is associated with criminal law. If you done something not in conformity with the law, you're sanctioned. Constitutional procedure has its own grounds of responsibility. Svetlana is quite right. There is general political responsibility, which is manifested during election. If, when being member of parliament or being in a particular position, you were not acting in the lawful way, then you will not be re-elected. As regards members of parliament, for some kind of transitional period, maybe it's possible. But Venice Commission will be against it. Probably one should introduce some mechanism of revocation of deputies elected, at least at local election. Responsibility of subject of authority in Ukraine is talk too much, just blah, 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 no result. To have real outcome, we need a political will. Although I do not like this work, it's not a political will, just a desire. You must wish to do something. And for that, you must force those who should produce this desire to do it. We have enough qualified lawyers who can produce quite perfect instruments how to exercise pressure on the authorities, that they exercise this desire. All our diseases and problems because of the status of entire society. Thank you. And now very last question, and we come to the next block. He was first, sorry. Dear experts, dear members of parliament, I agree with you. We have a holiday today, a Memorial Day. Ukraine made its choice 25 years ago, but opposing to esteemed academician, before asking my question, I shall make a proposal. Don't you think, especially esteemed expert, don't you think that collective irresponsibility is caused by shift of focus in political system? And there are certain personalities that are not responsible for anything, according to Constitution, like President. But on the other hand, the Prime Minister, who should be the head of executive branch of power the proper way, is not an independent person. Maybe the reason is there. But I want to come back to our commemoration and comment upon ballot paper. Excuse me, only one question, please. I refused the second question because we don't have enough time. It's just a comment. It's not a question. I don't need the answer. I'm sorry. Thank you for your question. We heard your question. The answer, please. If there is answer, partially there was the answer. Although the person asking said that he is not expecting the answer, I shall try to suggest the response. In fact, first and foremost, one should keep to provisions of the law and constitution. I don't know where, in which provision of the law you find lack of independence of Prime Minister. Constitution defines the powers of Prime Minister as well as the law on the Cabinet of Ministers. If each Prime Minister fulfills honestly what is prescribed there and acts in conformity with the interest of the country within the scope of his or her powers, things will go right. What you're hinting at, probably, that is done outside the scope of law. That means certain political relation, this is violation of the law, something else. One cannot adopt a law to prohibit violation of the law. That will not give you anything. Laws exist to be fulfilled. And society should watch politicians, that politicians fulfill the requirements of the law. Only in such a way you can achieve real responsibility. Thank you. I want to thank all speakers that took part in the first part of our block. More or less, we understood what law on the referendum is in force now, and that could be a clock mine for our country. I want to thank our partners and donors of this session, USAID, Government of Canada, Government of Great Britain, and IFES. Now, we come to the next block, how law on the referendum could be changed. What could be done? That is, clock mine stops functioning. I shall invite Denis Kovrizhenko, Senior Legal Advisor of IFES Ukraine, Viktor Musiyaka, Scientific Consultant of Razumkov Center, Dr. Law, Taras Shamaida, Coordinator of Movement Freedom Space, and Svetlana Kononchuk, Executive Director of Ukrainian Independent Center of Political Studies. Please. Somebody is missing. Viktor Musiyaka is not there. Okay, so we shall start without him. I invite Denis to speak. What could be changed? How we can make invalid the current law on referendum, and what the new law on the referendum should be like. Thank you. I shall start from saying that apart from domestic expert criticism, we had a lot of international criticism. Venice Commission in particular, they defined main drawbacks of this law and hence other ways how to correct these drawbacks. They defined several major blocks of problems in the current law. The approaches to wording the questions. Venice Commission was emphasizing that you can resolve any issue in referendum. Even appointment of particular positions could be put on referendum. The hierarchy of questions principle was violated. There could be a general question that includes a more specific question. This is in fact regulated by different legal acts, by constitution or by law. So this hierarchy of legislation is confused. Number of questions is not clearly limited, and Venice Commission put to doubt the possibility of adoption of new constitution based on referendum, because what constitution says that it is the chapter 13 of constitution who defines the procedure how constitution could be changed. This law on referendum even is more imperfect than the law on election to parliament of 2011. That was not a step forward, but rather a step backward. It was adopted for political consideration, both from the point of view of system and procedure. If we open this law on the referendum, if you take procedures prescribed there, situation is even worse. There are several things that Venice Commission noted that should be changed. First of all, among them, that was mentioned in the previous presentation, unequal status of those who are supporters of referendum, who initiate referendum, and opponents of referendum. Regulation of campaigning and financing, role of media, imbalanced coverage of procedure is not ensured by this law, and financing of referendum is not transparent, does not allow people to get information what money financed referendum and how money was spent. The procedure of setting up election commission is not typical for elections. That allows authorities to control the process of referendum through forming commissions loyal to common authorities. Regional councils can just appoint them. Procedure of registration of voters is also imperfect. You can get registered on election day, which is even contrary to election law from 2011. Because of that, because of these problems, we see the major ways how to improve them, how to correct these shortcomings. I want only to emphasize that this law, in the current version, it is unconstitutional. Broad discretion as regards wording of questions at referendum, imperfection of procedure, will not ensure holding referendum in conformity with international standards. What is the way out? In any case, the new law on referendum should take into account the requirement of constitution, international standards, and requirements of the election law. Even at the level of 2007, my personal opinion, legislation of 2007 was much better compared with what we have now. There is a draft law registered in Parliament that took into account requirements of constitution to referendum, and majority of provisions of the current law are brought in conformity with current legislation and with election code. As regards detailed procedure of counting votes and tabulation of results, because the current law on referendum doesn't regulate it properly. Very superficial procedure is there. Now, since this new draft law is registered in Parliament, it is the basis for further discussions on that, and I think that Parliament should start working on it. Even deputies do not agree with certain conceptual things. They can set up a working group that they traditionally don't discuss change, to get a political compromise in order that the new law on referendum is better, is in conformity with standards and constitution. That's it from me. Talking about the current law on referendum, to make it more perfect, it's like a heap of something should be made more perfect, looking more like bread. It's hardly possible at all. Thank you, Denise, for your presentation. Next, Viktor Musiaka, scientific consultant of Razumkov. He's not there, sorry. Taras. The floor is yours. Taras Shamaida, coordinator of the movement Freedom Space. Good afternoon, dear friends. I do not belong to fanatic supporters of referendum, instrument of democracy in general. Referendum as a sacred right of people to resolve the issues that people are not prepared for because of their professionalism. Organizers now thought, why did we invite this man? Among the organizers, there are also people who think like that, but they don't say it open. Even in the title of the conference, you can put comma or exclamation mark. You should not only rescue referendum, but rescue from referendum. Quite a democratic country, Germany, after numerous referenda held during Hitler time, after 1940 type, in principle, get away from using the instrument of national referendum. You can take USA, Canada, and numerous other countries where general referendum, it does not exist as an instrument. It's not by chance. Basically, it's dictator and dictators' regimes use instrument of referendum more often than democratic countries, especially national level referendum. This instrument was introduced by Napoleon, who was not a big Democrat at all. Napoleon held a referendum in modern meaning of this word. He got 99% of support, and then he repeated the referendum more and more, strengthening his power, appealing to the will of people. We know Adolf Hitler time, they introduced Führer position by referendum. They adopted numerous racist laws through referendum. If you take modern time, Lukashenko made a coup, destroyed parliamentarism, introduced bilingual principle by referendum. They were not all-nation referendum. Pseudo-referendum was held in Crimea. It is not recognized internationally, it has no legal force, but certain part of population, people who vote, people who stay in Crimea, that creates illusion of people's choice.
Therefore, this instrument is more manipulative. Although Mr. Shapovalov mentioned that many things could be considered manipulations, however, a referendum is more acute, more manipulative instrument, and in this case more risky, that we need to address very cautiously. The Constitution of Ukraine sets forth the definition of referendum, including referendum can be handled the popular initiative. Therefore, we cannot deny this right of the citizens. However, via the referendum, we have to safeguard guard the country and the public from manipulation. So, referenda should be democratic, and there should be the most significant subject matters addressed by the referendum, where clear answer is possible. Somebody mentioned 1 December. I want to go back 25 years. This was the example of very appropriate use of referendum. On that day, I was observer in Luhansk town in the east of Ukraine, and it was democratic procedure there, it was democratic voting and appropriate counting. This is an example of good referendum. When first parliament renders a decision in a democratic manner, and this was, by the way, a text of Act of Independence, and this whole text was included in the ballot, and the question was, do you support, do you not support? And also the previous law, let's look at it. It was, I believe this is a very good law, only it had a different purpose. If you read it carefully, you would have noticed that at all phases, from the initiative group, articulation of the question, and then handling of referendum, that was the instrument of manipulation with the decision that is imposed to the country. And if you ask me questions later, I will tell you why. But for example, only the government may initiate the referendum, and Mr. Koleushko, by the way, here mentioned that the Constitution does not has no provision or procedure about how a new Constitution can be adopted. Actually, it states there that no new Constitution can be adopted. There may be a different version or some changes adopted, but not a new Constitution. And this is a democratic procedure. When the Parliament, for example, by 2/3 of votes adopts the changes, and they may be supported or denied by the referendum. And if somebody wants to draft something that he or she would call Constitution and Ukraine, and then vote for it, and according to the new law, and state that this is, then pronounce this is your new Constitution. Also, commissions are established by only the power, by only the leadership, and those members can be replaced at any time by the leadership again. And campaigning. Campaigning here is only allowed based on the contracts. Campaigning is through the media we are talking about. And if media mentions something about the referendum, for example, they can close printed media and suspend a license of TV or radio broadcasting company. And that's all about the campaigning. Observers at the voting day, they could, apart from international observers, they could only be, but domestic observers could only be representatives of initiative group. I can continue this list of manipulations. Voting at home, according to this law, then announcement of the results, when even CEC cannot have a say here. Only what is important is for the CEC chair to announce, and that's it. Let's say the president drafts a constitution, then organizes for popular support, and then the chair of CEC will pronounce that the new constitution is in effect. And what is important for us to understand that this current law is like a very dangerous mine, and however, the leadership cannot use this as an instrument, use this law, because we have civil society and there is no strong chain of command across the country. But it doesn't mean that there will be no attempt to put pressure, military pressure, whatever other pressure. We have to demine this process, this mine, as to be put away with. And why it is important? The Constitutional Court has delayed this addressing this issue for 2 years, although this is the most unconstitutional law. On the other hand, why is the Parliament delaying addressing this issue? Because it's very unparliamentary. Again, this law gives an opportunity to bypass the Parliament in the adoption of new laws, with the adoption of new laws. Therefore, I believe it is the mission of both politicians and civil society to draw attention to this law and destroy this very hazardous and dangerous Carthagen. And there is draft law 2145 that was forwarded to the Parliament in 2015. It has no such risks. There is a attendance rate described there. There is constraints for manipulation. So I believe it would be only very expedient to adopt for the Parliament this 2145 draft law. I give the floor to Svetlana Konovchuk, Executive Director, Ukrainian Center for Independent Strategic Studies. And what we are seeking answer to is how do we amend the law? What do we do with this old law to make it non-existent and have better effective laws in place? Svetlana, and I apologize, I have forgotten those ballots. There is a box here that you have in your files, that you have in your folders. You can drop them here, please. Can you replace a member of the Commission on the day of voting? Okay, let's listen to Ms. Svetlana. I don't think I have the answer about how to deal with the current law, and I was very much surprised by the judge of Constitutional Court, who said that if the Constitutional Court will terminate the proceedings, this will automatically mean acknowledgement of the constitutional nature of the subject matter. Well, speaking about this law, there is constitutional jurisdiction and it has a huge gap that we have to address. A constitutional court cannot be so passive, and its passive attitude should not become legal ground to not acknowledge the constitutional nature of the whatever subject matter. And I'm very honored to make presentation number 1 of those developments that have been elaborated on by our working group. And the authors of this law, they are hiding back. Mr. Lavrinovich never admitted his contribution and as an author, and the MP who is stated that, as the author of this draft law. Unfortunately, during all these years, never ever took part in public discussions with regard to this current law on all Ukrainian referendum. And them keeping silent is another message of the huge threat that this current law implies. First of all, I would like to say a few words about those who drafted this new version. I would like to say that IFES supported the drafting of this new version of the law of on all Ukrainian referendum, and also the best lawyers contributed to the drafting. There were representatives of IFES, and there was expertise from Ministry of Justice and many NGOs. Also, after our voting is over, I also wanted to mention that it took us about 6 months, and we were very committed. And let us briefly present those developments of the working group. What have they proposed? What we were based on is that the a referendum should not become just another survey to ask for public opinion. If an entity or some leadership wants to do some survey, even if it covers 30 million, they can very well do this. We believe that referendum should be an instrument of involvement of the public in public administration processes. Therefore, we suggested that the referendum should involve one subject matter, so we limited the number of issues that may be addressed by a referendum, and secondly, that the public or people should state whether they support or whether they do not support some legal act. Just give an answer yes or no. So we believe that our proposal will prevent any manipulation with the results of a referendum. So, like we have had in the past, when, for example, we have results of the referendum and then the parliament wants to decide what to do with those results and produce so many draft laws to deny the results of referendum. And so our proposals are supposed to prevent any such manipulations and to ensure that this legal act that they support will be adopted, and whatever legal act that will be addressed by the referendum, it will be also included in the ballot. Like in 1991, for example, this Act of Independence of Ukraine was the subject of a matter of referendum, and the people were supposed to give an answer yes or no with regard to this legal act. We also suggested that those limitations that are included in the current constitution are retained in the law on the referendum. We believe that we shouldn't vote at the referendum concurrently with voting, and at the same time concurrently with a parliamentary or presidential election. Well, it may save time and effort, but it's very difficult to ensure good discussion, effective discussion of the issue that is to be addressed by the referendum. And then this will be challenging for the Commission in managing the overall process, including the voting process. Therefore, our idea is to have elections and referendum to deal with them separately. Also, we shouldn't initiate the issues regarding the territory. There is appropriate provision in the Constitution. And Volodymyr mentioned that this back in June this year, the provision was included in the Constitution for the Constitutional Court to have the authority to evaluate the issue to be addressed by the referenda, to identify how constitutional, whether it is in line with the Constitution. This could be a very good approach to avoid any initiatives, any for the referendum to initiate unconstitutional issues or those that would jeopardize the existence of the country. Then we also offer our vision, which is based on recommendations of international institutions with regard to involvement of the public. There is the process and procedures regarding the establishment of the Commission. And currently, commissions in support of referendum, how they are established, they are dependent on those entities that establish them. On the voting day, any member of the Commission may be challenged and replaced. And without any voting, and the report may be signed only by those who agree with this report, and there are many risks involved here that may result in falsification of results of voting. So what we suggest is that how they should appoint members of the Commission, for example. They should be nominated not only by members of the working group, but also the parties should be able to nominate members of the Commission. And also supporters and opponents of the issues at the referendum, they should be registered by the CEC to campaign for or against the subject matter for the referendum. So this process should be open, and it has to do with the funding, also this campaigning, and so the parties should be able to nominate potential members of the Commission. And results and decisions of the referendum. The results of referendum will be proclaimed by the chair of CEC without any possibility to challenge it. This is according to the current law. According to the current law, the results are declared by the chair, and there is no way of challenging. Our group demands that the act should be published, that the act that was the subject matter of the referendum. And also we revise this situation where the decision of the referendum could be adopted by a minimum of people, and we want to include the provision so that the decision is adopted by the majority of those who took part in the voting. And those decisions of the referendum should be binding and shouldn't be subjected to some additional interpretations. Since we are saying that the referendum either supports or denies some draft act, therefore those who voted for make a legal ground for will actually build up and make legal ground for implementation of this act within the legal field. So again, we make the popular initiated referendum feasible, because currently Constitution stipulates for 3 opportunities to initiate referendum. Number 1 is when the Verkhovna Rada, the parliament, announces referendum with regards to change of territories. Option 2 is president initiates referendum to amend the constitution. And number 3 source of initiating the referendum is the people. We believed in our suggestions, what we propose. Of course, first 2 entities may initiate a referendum, but we wanted to safeguard the initiative of the people. Therefore, we offer some simplification with regard to the composition of the initiative group. Then the number of meetings, to change the number of proposed meetings, participants over 300 voters, and there are a few other ideas that we come up with that will ensure a referendum. And we hope that this draft law that has already been registered and is awaiting goodwill of MPs will enable this progress of referendum into the legal field that will prevent any falsification of the results of referendum, of the outcomes of referendum. And so we can only promote this emerging new culture of handling referenda to prevent any possibility to use them for the purpose that is against the will of the majority of citizens of Ukraine. Thank you. And according to the current law on the referendum, we continue with the counting on the knees, which is a good approach. Then now we will have a Q&A session, and then we will announce the outcomes of our local referendum. To the speakers, please, would you have any questions, or maybe you have some answers to share with us? There is one question. Microphone. Do I understand you right? that you are working, going to work with MPs and MP groups. Who will be your allies, and will the IMF be one of these allies as a tool of pressure on decision making? And the president also in this system coordinates. Would you include him as your ally? Maybe he will take the leadership in this process. Well, I believe the broader the circle of allies, the better it is, particularly when they are as influential as the president and the IMF. I believe the broader the coalition is, public or political, the better it will be. Maybe the president of Ukraine believes, or his surrounding whispers to him that this is such a great instrument. If a parliament doesn't want to approve the changes to the constitution regarding decentralization or any other developed by the Constitutional Commission, and this is a great instrument for us to have it adopted based on the referendum. And also, when we can concurrently have election, presidential election and the referendum, voting for a referendum, when we take dictatorships, for example, this is quite common when, for example, a presidential nominee also brings the issue, for example, to execute all current MPs or whatever, using it as an instrument, this referendum, you know, but this is with dictatorships. However, this instrument could be used against the president, and I am more than convinced that back in 2012, Medvedchuk and all other pro-Putin individuals, they did not adopt this law not for Yanukovych, but for the future loss of independence by Ukraine. They were telling Yanukovych, this is a great tool for dictatorship when you will be able to adopt any law without parliamentary contribution. However, they were focusing on 2015 or whenever they wanted to restore the Soviet Union. So that they take control of the country with military force, for example, but outside Ukraine.
Therefore, this danger remains even now in conditions of war with Russia. Under the pressure of situation at the front, Minsk agreements were concluded. We don't know what other documents could be adopted because of military pressure or Western pressure. Better we cancel this law and adopt a new law on referendum. It will be better even for the president, because according to the new law, the president with support of people can realize his wishes. As regards IMF, it's more difficult, but you can engage different international organizations, because we should draw their attention as well how dangerous the current law on referendum is. There is conclusion of the Venice Commission, how dangerous this law is. There are conclusions of other organizations. Things should change. And international organizations should remind our authority that this law is dangerous. But the first ally should be Parliament, because this law is against Parliament. It's anti-parliamentarian. Like parliamentarism was destroyed in Belarus. President Lukashenko called for consultative referendum. They said it's not direct action referendum. We want just to ask people, do you want to reduce number of members of parliament to 100? From 260 to 120. And people agreed. They had a very loose procedure. 20% of people voted at home. The people agreed to reduce members of parliament to 110. Naive members of parliament thought that it would be better for them to approve new laws. But as soon as voting finished, Lukashenko issued a decree saying that now, from today, number of members of parliament will be 110. And he chose from 260 deputies, 110 deputies that he liked, and they started functioning. And then Lukashenko was saying, but it's the people who decided on that. Using such an instrument, dictatorship could be installed, and such a risk should be removed. Any questions, or you are just shocked understanding what kind of law we have in force? Please take the microphone. We have direct streamline. You said that in the referendum law, there is a possibility to change the territory of Ukraine through referendum. Is that a good provision of the law? This is the most normal item of this law, even the current law. Why? Because Constitution of Ukraine says that territory of Ukraine could be changed only based on the results of all Ukraine referendum. That is done to avoid change of territory without will of people. It is one of the few provisions of the current law that is more or less okay. Only after decision of parliament, still people should confirm this decision of parliament or reject it. The other thing is that procedure in the current law allows to falsify will of people. Procedure should be changed. Actually, you should confirm whether you're not against of taking Crimea back or Kuban for the future. More questions? A few words about results of referendum. You know the results of referendum. Before Yulia announces our results, I must say that the current law is designed in such a way you can ask a very abstract question. And after that, it will allow authorities to say, people decided on that, and now we shall implement it. Svetlana was talking about that. Manipulation will be possible, Lukashenko type. This law does not give the procedure how results will be implemented. What is specified only that these results will come into force without any approval. So, according to results of referendum, it's possible that during coffee break, instead of coffee, you will get vegetarian menu. It's the least evil that may happen. Thank you very much. We have the results of voting that you did today. We call it not local referendum, but all Ukraine referendum. Why? According to the current version of the law, there is no difference. How many people took part in the referendum? 40 voters took part in the referendum, and despite that, results are valid according to the current law. We have 5 ballot papers that had some reservations regarding the form of the ballot paper or because the wording of the question was incorrect. But according to the law, we should recognize them invalid. 5 ballot papers are invalid. One voter, who is deputy chairman of Central Election Commission, he's in high position. He made very valid comments, but his ballot paper is valid. I think punishment should be introduced for spoiling the ballot paper. So we do not have any sanctions, but this will not influence the result. Out of 40 voters, 5 are invalid, 25 people voted for, 6 voted against. It doesn't matter what question. I'm repeating the question. According to the law, since the moment when the chairman of Central Election Commission announces the results of referendum, the decision comes into force, and the chairman or any other person from authority reading it. So I can act as the chairman of CEC. The question was, whether you support accession of Ukraine to economically dependent Europe, where respect to family values and historic roots is a priority of state policy. We used Europe, which Europe, it's a geographical name. Europe, which includes Russian Federation, from western border of Russian Federation to Ural Mountain. And this Russian part of Europe has a priority of family values and historic roots. Actually, we voted for accession to Russian Federation. Such a sad result of voting. But this is not just a mute voting, because the current procedures existing in the law on referendum allow us to organize it like that. If during campaigning somebody starts arguing, the question is worded incorrectly, or let us specify what is meant in this question. You can use media, and if media writes something, you can revoke license from media. You can revoke license from TV channel. It will not broadcast until the end of referendum. These are the norms contained in the current law on referendum. After such results of referendum, actually, I expected that less people will vote for. But that demonstrates once again what danger and what risk the current law on referendum brings. When in the question we don't have very specific things. There are no requirements regarding wording of the question. That a legal act should be specified. Yeah, I shall not repeat all that. It had been mentioned by experts before. So if you don't have any objections, what I want, when summarizing the result of this forum, I would like that we adopt a statement or declaration of participants of this forum, where we should state once again that current law on referendum is unconstitutional, and we appeal to Parliament that they, without any delay, adopt a new law and establish a new procedure which will be lawful. We shall address the President, asking him, being the guarantor of Constitution, to say his word, and not indicating maybe, not interfering into the constitutional justice. We shall draw attention to the Constitutional Court that to consider this question for 2 years, it's too long. And we shall remind Constitutional Court what is their major task is, according to the law. If there are no objections, we shall distribute to all participants of the forum the text of this statement, and then we shall send them to all mentioned authorities. No objections? Therefore, this document, this statement, will be sent to all of you, and then we shall officially send it to the relevant authorities, and it will be placed publicly on the internet and on the websites of particular international organizations and on IFES website. If you have your regional organizations, we will be thankful to you if you place it on your website and publicize this document as broad as possible, because our position is it's not enough to understand risks that this law brings. The law remains in force anyway, and the other side understands very well that they still keep this instrument in their hands. I will thank all experts Do you want to say anything else in conclusion? No. Then I thank all participants that arrived from different regions. Next week we shall travel to Dnipro, Kharkiv, Lviv and Chernihiv, discussing the same topic. People, civil society activists also understand the risk of this law, and we shall discuss same questions in other towns. If you are ready to get engaged to this civic campaign, please get engaged. We are ready to help you, providing you the brochures with some expert conclusions, with Mr. Shapoval article, with international document that regulate procedure of national referenda. We shall keep contact with you. Thank you for coming, and I want to thank international organizations that supported us all this time. We want to thank IFES, USAID, the Government of Canada, and the UK Embassy in Ukraine. Goodbye to all of you. I cannot even imagine how attentively you will read the text of this statement that we sent to you to avoid any intricate thing. Thank you all. Coffee is waiting for you. You can continue communication informally.